Good afternoon. This is a very relevant topic, and the objective is that the participant knows all the guidelines of the online trial. And this presentation will be delivered by Mr. Professor Alejandro Ferral, and we will ask Judith if she could read his resume. Thank you very much. Professor Pedro Alejandro Ferrar Cid. He has 20 years of experience in fiscal, administrative, and corporate subjects as a lawyer and advisor. He has a BA in law in Campus Acatlán in the National Autonomous University of Mexico. He has a master's degree in fiscal administrative law in the National Bar of Lawyers, AC, and also he has a specialty in constitutional law for the UNAM in the Faculty of PhD Studies, and he has different specialized courses in the Mexican Academy of Fiscal Law, among others. I will give him the floor and the mic to Professor Pedro Alejandro Ferral Cid. Welcome. Thank you very much, Judith. I'm going to share my screen to give my presentation. Okay. So before we begin, I just want to greet all the associates of UC&CS. And also I want to thank the firm for inviting me to this 22nd global meeting in a virtual modality. And this is caused because of all the inconvenience of the pandemic. This is the second global meeting under this new modality. But on the modality of the online trials and the use of technology and all the changes in terms of technology that have been addressed during these days, and also my talk is related to this. So for this purpose, I would like to share with you some historical background on how the new technologies have been shaping and changing the jurisdictional activity of the states, but also there are other activities related, as all the administrative proceedings in all aspects of the federal public function. And this includes the use of advanced or state-of-the-art technologies. It's true that because of the pandemic, this process was accelerated gradually and benefited all the citizens. But we cannot consider in any way that justice and administrative procedures online were born because of the global pandemic. On the contrary, we need to analyze how the new information technologies and communication have had an evolution for more than 20 years of history. And this is why this analysis will be done. Currently, only to supplement this introduction, in worldwide there are different online trials with different proceedings and procedures, and using all electronic means as internet to have legal certainty in all processes. What are we given is information to the citizen, the user, information request from governments, and also transparency in the review of accounts, and also to the administrative and justice proceedings locally and internationally. We are facing, if we are facing just a technological evolution, we should ask ourselves if there's a law as a regulating standard. So the first questioning would be, or the one that emerged in this parameter, what the Declaration of the Right to Development issued by the UN with the trials and proceedings online as the historical data. This decree was adopted by the Declaration on the Assembly of the United Nations in 1986, and as of that date, all the signatories countries, members of the UN, have to adapt the legislation to their treaties or decrees. Therefore, it turns out that it's really relevant, the Declaration of the Right to the Development. Why? Because this considers, and it is recognized, that the law, it is a inalienable human right, and within this right, people have the right to participate in the economic, social, cultural, political process, and this in order to continuously improve the welfare of the population. So therefore, the states have the right and the duty to formulate public policies or national policies to incorporate them in this law to the international law according to the legislation and regulation, improving or with the lens that always surveilling the welfare of a population. This is foreseen in the first two articles of the Declaration. But it is also important to observe Article 3 of this Declaration, because this Article number 3 establishes the essential duty of the state that has to implement or create the conditions at a national and international level favorable to realize the right to a process. The states have to guarantee the necessary means to achieve the economic, political, and social welfare of the population, through the implementation of standards of international treaties or national legislation that will favor, in all senses, the application of positive law in the states, and in the case of the Latin American countries, or we need to legislate those applications and standards in the use of new technologies so they will properly be used. So we go to the next topic. The information and communication technologies that will be called TIC or ICT in English. The ICT should materialize, as we said before, in a legislation, and this legislation has to be reflected in public policies generated in the field of legal administration or in the administration of governments. And with this, we'll have a fairer or a more just administration based on the technologies, and this will lead the society to have access in a more inclusive manner to more inclusive information. And in this way, we provide transparency in the information and even in the enhancement of environmental conditions, like the no utilization of paper. Therefore, the ICT in the context of globalization are essential to maintain us interconnected with all the society and with information generated by this and by the state itself. And this is performed from a known means: emails, social media, digital platforms, communication platforms, radio, TV, digital news, and even the communications of the own state. All of this is reflected in endless technologies known and to be designed. Well, regarding dwelling into the theory, because it's really important, Edgar Tello Leal defines that ICT is a term that includes any way of technology to create, store, exchange, and process information by the known and unknown ways. And this through the ICT for law procurement and administrative online proceedings, we can improve the performance of the judicial system, from the link to the society to the material organization and realization of the administrative proceedings. Well, therefore, it generates access to justice in an expedite way, and the administrative proceedings in any aspect of the government and through the use of internet and digital means. We could think in two terms if we need to visualize the term of the e-justice or digital technology before and after the pandemic. And here, if we do not have prior knowledge of access to e-justice, we can think about the first plane that due to the pandemic of COVID-19, this was a determining factor, so the judicial branch in a global order, not only national, have had to adapt themselves in terms of a structure to a new normal that consists of having social distancing. And this led to the use of online trials of e-justice. Each one is different. And derived from this, there's the utilization of the different platforms to perform and have access to justice, like it will be the communication through a digital platform, like we are doing today. So we consider the facts occurred since 2019, at the end of 2019, January 2020, that according to the progression of the pandemic at the global level and the social and governmental limitations, the suspension status of the acts of government and in almost all the government level, federal, state, and municipal level, and executive and legislative and judicial branches also were evident in the suspension of activities. And if this happened in the government, this was evident in the acts of individuals. And with all this explanation, as a summary, we can think that regarding law procurement online, this stemmed from the pandemic. I'm going to express three key examples occurred during the pandemic, and they were disseminated because the new social legislation and the global context on which the facts were occurring. So this occurred in April 2020 in Coahuila, Mexico, where in this state the first oral trial was done through video conference and dictating a sentence just at the very beginning of the pandemic. Probably this is not the first case where technology was used, but this is the first case at the national level where it was massively disseminated because of the social context we were experiencing. In Argentina, the same thing during April of 2020. It was imposed through Zoom platform, life sentence to a feminicide, and it was disseminated through communication or through the media. And likewise, in May 2020, Singapore, a sentence was dictated through a platform. So with this, we can observe how the administrative proceedings and the online trial, with the help of digital platforms and video conference, not only they had helped the jurisdictional activity of the state, but also they have helped to contain the virus, to maintain a separation between individuals, and also they have demonstrated that the procedures and law procurement can be more agile without needing the human presence to carry out the process. However, this is where we have this situation. The technological development is not a matter of easy application in the States, because the correct use of this technology implies, on one hand, great benefits for the state and the population, but on the other hand, implies serious difficulties in its materialization, and all of this has to be performed by the states, not only locally, but also globally. And we shouldn't left aside that the online trial during the pandemic and other administrative procedures that were operating before the pandemic. I'm going to give you some examples of what has been happening before COVID and how technologies and their implementation were happening before. In the case of Singapore, since 1999, it was implemented the Law of Access to Justice that allows the video conference may be used in hearings. And also, besides the law, it was a system called mobile justice was implemented that allow the judges and commissioners, judicial commissioners will have remote access from any place they decide, even from their homes. And for this purpose, the state provides all the necessary tools so they can perform their jurisdictional task: portable computers and high-speed internet. The state also has another function besides giving internet. It also has promoted greater levels of audiences, or greater levels of audience will have access to this system. And for this purpose, it has established technological forces, and this facilitate all the establishment of lawsuit and the evidence or documentation of the lawsuits. And for this, there are 5 special courts that they can be used according to the technological needs of each case. In this way, the users, that could be the actors or the public officials, can have access to high-speed technology or high-level audiovisual technology at any time. So we're talking about the existence of a mechanism called e-justice. So please have it in your mind. So in the case of the Netherlands, the courts use a system to manage common cases in which all the parties have access to the judicial system. And the litigants, as well as the authorities, can upload recordings of audio and video and digital probatory documents, so the court will do whatever it is necessary to dictate the sentence and perform their jurisdictional activity. In the case of Mexico, the use of ICT technologies occurred with the administrative law that started operating in 2011, in August 2011 to be precise. And this administrative digital trial allowed the litigants to carry out all the process from the presentation of the submission of the lawsuit until the sentence digitally, going through the presentation of evidence, the recognition of the expert opinion through electronic means, and according to the legislation. But in Mexico, how this process began, the digitalization of a digital trial, it didn't start in 2011. It started 11 years before, when it was the Federal Code of Civil Proceeding was amended, and in this code it was recognized the digital evidence. It is recognized the evidence pre-generated or communicated through electronic means or optical means in any other technology, and this was the first step in the technology for the progress of digital proceedings or trials. Another law that allows implementation of ICT is a Code of Trade that was amended in 2003, and the legislator foresaw the authorization of the electronic signature. And through this Code of Commerce, it was established the definition of the electronic signatory and advanced electronic signature, and issuing in 2011 the regulation of the advanced digital signature, giving the power to the Secretary of the Treasury and the Secretary of the Economy. And also the legislator establishes that the Secretary of Treasury will be in charge of the advanced electronic signature. So these two elements, or these two laws, prior to the issuing of the regulation of the digitalization of electronic trials, allowed the digital lawsuit while with the validation of the advanced signatory that allowed the recognition of the juridical person in the trial. This does not happen in other countries because the advanced electronic firm is granted by decentralized agency or individuals that have the license to control the advanced electronic signature. Although in the U.S., not even the personality, legal personality, has to sign a lawsuit. The one that signs the lawsuit is the attorney that is in charge of the case. Also, the facilitating the technology and access to justice, not the traditional limitations. Well, in the case of Costa Rica, Costa Rica is another country that was a pioneer in the use of technology in the case of digital trials, because in Costa Rica have had no paper trials derived from the program Zero Paper. And this program at an institutional level tries that all the formalities that are not necessary will no longer be a barrier, so people will have access to the management, to the to law procurement without technology. In the same way, they have materialized the trial towards their program Zero Paper while issuing laws according to their legal regulation, like the administrative law amended in 2006 that determines that all the aggregated documents added to the writings can be certified digitally, something similar to what is happening in Mexico. And besides the reform, and also the regulation was issued in the electronic file in Costa Rica in 2008. And this law regulated all the proceedings and digital processes. And with this, there was a plan of digital justice by incorporating the electronic trial, oral trial model that it's a great success of that country because they allow the mercantile, criminal trials, administrative trials of a fully digital process. In terms of the public administration and the use of technologies, Costa Rica has implemented within its programs or in its web page specific sites with transparency programs, with access to the information and everything related to the administrative management, leading the ICT to all the administrative proceedings of the government. And in this way, we can reach a first conclusion. When we listen the word e-justice, we're going to consider as such those processes that happen within the judicial branch at all stages. And while with the use of ICT, we reduce time, cost, access, and transparency to justice and elimination of corruption. The facilitation of the user in web pages, as well as the facilitation from the person that is judging. So this is very different from the digital trial. The digital trial does not happen it's a limited digital trial, because in this case the state only provides that the user may have access to a visualization in a list of what is happening within the process without having the user having access to what the other party is submitting. And we see this more or less in the judicial process in the federal district, and also in the digital platform that was used by the judicial branch of the federation before the reform. And they only have access to the file in the digital trial, but without having access to the acts. We have a difference with e-justice and the digital trial. And continuing with this, we will talk about international law. The Center of Facilitation of Commerce and Transactions of the UN, CEFAT, its main goal is to facilitate trade by contributing in the being more expedite in the border trade. And those are the guidelines that we can observe in our national legislation. In the case of Mexico, when we talked about the unique window, it is necessary to review all the documents and the guidelines of the CEFAC page of the UN to say that since 2011, Mexico took those guidelines and incorporated to our legislation. So Mexico just emptied out all those guidelines and applied them to Mexico. And what do we want to do with this? To reduce the utilization of paper.
Reduce corruption, making transparent trans-border trade and uniform application of criteria, everything in the benefit of international trade. At the international level, this is so counter in terms of CEPAC guidelines. Now it is understood as implemented technologies to house information and documents related to regulatory processes needed by law in order to import, export goods and services. In the same way, CEPAC guidelines facilitate exchange of trade information relevant among government agencies, the state, and traders. However, it also facilitates exchange among traders and other service suppliers of the private industry. All these 7 days a week and 24 hours a day for users. As we can observe from these 5 examples, the use of these technologies and the application of human rights as the participation of development, because we need to remember that this right is unwaivable for human rights, and this as the Declaration of Human Rights, states have the obligation to create conditions at international and national level for the implementation of justice and some paperwork. All these in order to make efficient judicial procedures. And this fact has been materialized from 20 years ago, and not only as a result of the pandemic. In this slide, I show you the evolution of this process. Contrary to what we have analyzed, where we have these evolution parts of the tick before the pandemic, we have the presence or evolution as a result of the pandemic and the use of technologies. And for this, I am showing you how the pandemic improved access to justice, exercise the third province in Argentina to implement e-justice, not online trials, but e-justice. And let's say this differently, the introduction of all this judicial process by users. This is a clear example on how Latin American states, due to physical and operational limits, had correct impositions to carry out this judicial process. Regretfully, I cannot say the same of the Mexican judicial system. As a result of the pandemic, it also suffered a paralysis for operation during several months. We're talking about from 3 to 4 months that there was no Mexican justice until courts were reopened. And then they started operating with some restrictions. However, the implementation in a mandatory manner is not carried out for e-justice. In other countries such as Argentina, Chile, Costa Rica, just to mention some Latin American countries, they have completed necessary actions to implement e-justice as a mandatory part for all users. And here, which could be the key for success for e-justice in Argentina? Talking about the scope of this service, it turns mandatory for civil subjects, labor, family, and criminal courts the implementation or the use of this e-justice concept. It is necessary to point out that in the criminal area, they are not using paper since 2017. Now, talking about central files or in process, that means all files generated as of August, they will continue until their completion until this process. And this was implemented in August. As of August, we don't see that website, but I guess it is August. So all procedures that were digitals will be completed as digital. And now talking about matters that were generated physically, because we had paper lawsuits or any other element during the process, the whole process would be digitalized, and in the existence of the program, everything would be digital. IT security, the obligation of the state to safeguard servers and everything related to IT services that are highly qualified. And with this, we're going to have access and also the transition security to the process. Also, file query. Since this online file system was implemented in Argentina named XXII, So you can do this without having to go to trials. You have remote access to justice in a remote manner that implies more access and more hearing systems in this Sion system. Advantages, benefits, there are plenty. And processes speed up, they decongest entry desks, transparency in information, and also transparency during the process, savings and benefit of inputs, and also protection of the environment. And the most important thing, which has also been mentioned, the total elimination of paper, protection to the environment. Out of this, we have the achievement of Argentina. Well, we need to see figures because we're talking about from August to date, 27,000 judicial processes, 879 files opened by the public prosecutors, 1,700 judgments that are digital, not physical, more than 4,500 people that were defended, more than 350 criminal hearings, 200 by Zoom, 17,000 submittal of new matters, and the final one could be 1,500 mediations and remote reconciliation. It is important to mention that this third province, which is the third in size, also implemented in the system mediation and reconciliation, reflected in the figures that they are submitting at the website. It is really very important what they have done in all this digitalization process of their experience. It is commendable. And we have not been able to do that in our Mexican legislation. And now, I'm going to show you a comparison of courts. The Customs Tax Court, which in the Mexican administration, for those that are not for Mexico, is the Fiscal Court for Latin American countries. To the left, we have the Chilean court, tax court. There is a chart of the number of trials submitted since 2010 to 2019. As we can see, 2020 and 2021 do not show up. I tried to download statistical data of this website from Chile, but these data do not appear for 2020 and 21, and this is a contradiction to the principles of communication, because what we see here is that we need to have statistical current data and real data, and these are not appearing in this court with access to information. In the case of the Chilean court, happens the same as in the Mexican. Access is allowed to submit a lawsuit by digital means, but there's a contradiction here. Why? Because the Chilean court allows me to file a lawsuit. But contrary to this, it establishes that the Chile court should incorporate a printing of the physical file. It means that the court needs to spend money in paper to have a backup of this physical file as well as in digital. And this is a hybrid program of technologies and e-justice. If we are talking about justice, all the digital process has to be completed from beginning to the end with this figure. In the case of the Mexican process, it is very different. We are talking about having online trials and an e-justice fully implemented since 2012. However, if we see statistical data up to December 2020, according to the court website, only 1,046 new files have been submitted in digital form. And on the contrary, we have more than 30,000 lawsuits in special and regional courts in a physical manner. And this is saying that e-justice implemented since 2011, which was back then a technological advance, has not reached development that as it was expected. Why was it? Mexican legislation regarding regulatory laws of the administrative courts foresees two situations that as a litigant lawyer you can choose by submitting a trial in a physical or e-justice manner. And when I have talked to them why you are not doing this digitally, I feel more comfortable with a physical lawsuit. But there are great benefits and advantages in doing this digitally. One of them is that you don't have to go to the courts, and if you have to submit a lawsuit at the Southeast, you can do it digitally from Mexico City or where you live, and this process will be digitally managed. Number 2, you are saving procedural process. Number 3, you don't have a physical file, implying not to spend in paper, but you have to be careful to safeguard your information in a digital manner, because that's the one that you're going to submit to the court. And the requirement is that you need to make patent that this digital document that you're using corresponds to an original document, a certified copy or simple copy, or a private document prepared by the parties or the claimant. Which other benefits? Access in a remote manner and visualization of the process in a concrete and timely manner. And these are some of the benefits that are generated in a digital manner, but which truly the state has not tried to implement the digital trial in a fully online manner, because it still allows the use of old ways that are obsolete. Now, the use of digital technologies in the application and development of law, as the use of artificial intelligence. It is also being implemented not only by particulars, because we can even see in digital networks and other platforms how the use of platforms or offering services are patent from the incorporation of companies, digital forms, contracts, etc., that do not have the backup of a law firm that are offered in the internet, and in some other instances they do have this backup. We need just to be careful. But talking about artificial intelligence and the use of algorithms, I found 3 cases at worldwide level. The first one is the case of Argentina. Argentina in 2017 implemented a multidisciplinary team made up by the public prosecutor, so it incorporated a multidisciplinary team made up by the public prosecutor and the fiscal of Buenos Aires City, along with experts in artificial intelligence, and they created the program named Prometheus. It's the first intelligent system resolving cases in a very short time and with high accuracy for authorities. And the fosterers of this system state that this program is capable of resolving thousands of experiences in only 7 days. And this task, if it is done by traditional means, will consume 83 journeys of works, a difference of 76. And if this program is so effective by the use of this algorithm, then we would have to bring it to Mexico or other countries for the implementation and the solution of these conflicts that are in a backlog for many years. I have just read some news from the Chilean court saying that in the case of Pricewaterhouse, they were sanctioned along with the company due to a problem of fund sale. And this trial has taken more than 10 years in being resolved. It doesn't mean that this program is useful for all cases, but they can resolve 1,000 files in 7 days. This is given some support to resolve conflicts. And how does this system work? The system seeks to give first and second instance judgments and then analyzes more than 1,400 cases that are previous investigations or resolutions of the public prosecutor. So finally, in a few seconds, they can issue some forecast or a possible solution applicable to this specific case. In this way, this TIC technology becomes a reality. In the case of the United States, there is a system called COMPS. Its meaning of the acronym is Correctional Management System. And in translating this, it could be management profiles for correctional perpetrators. And this system has been implemented in different states of the American Union, and it works by means of a company. And the name of this company, it's a kind of profile administration of criminals or offenders to look for alternative systems to prisons. This algorithm basically works based on a questionnaire providing 137 elements of investigation that are formulated in this system. When these persons are arrested, and it also weighs the background of this person, allowing the program to determine if the arrestee could commit a crime in the future. This helps the judge to determine the risk value or score and decide whether someone can live on parole, should be sent to prison, or receive an alternate punishment. And even if they are already inmates, the algorithm will determine if they deserve freedom on parole. The Court of Wisconsin has considered that it is completely ad hoc to the Constitution the use of this program with this algorithm used by a proprietary code of an individual company. This allows and helps the judge to determine the conviction. It speeds up the procedure. However, the Supreme Court of Justice determined that this program is efficient, and it also triggered some critics to the problem because it determines that the program may grant ethnic minorities risk scores out of proportion, and this is a weakness of the system, taking into consideration current tensions of the police corporations with the population As a result of racial discrimination and inequality due to ethnic, economic, and social factors. But this observation made by the Supreme Court of Wisconsin has a logical reason. When we talk about equality, the principle of equality, as it was mentioned, we would be violating this principle according to the American Declaration of the Duties and Obligations. Article 2 establishes that all people are equal before the law and they have the same rights and duties without distinction of race, sex, gender, creed, or any other reason that would make a discrimination. So, as a result of this American Rights Declaration, there should not be any distinction, and the program limits, or it's limiting this because there's a distinction here. In the case of Australia, there was also a program or system called Suspect Profiling Management Plan, which also uses an algorithm quantifying probabilities that the person can make a crime again. So in other words, this program works by means of a pre-crime study using artificial intelligence to identify potential criminals based on big data. Based on these historical records and variables and police variables, they determine the conduct of people. So then it classifies criminals due to their risk in this part with a relapse as a high, mid, and low. And we can observe how investigation technologies using algorithms is a reality not only at private level but also at public. And finally, now getting in the final part of my presentation, we were talking about facilitating trade with TICs. This rises as an important factor in the economical development of countries because due to the impact in competitiveness and the integration of market to attract foreign direct investment in the last decade, it has allowed in this political international agenda and as part of commercial relationships of the World Trade Organization and due to technical programs, so developing economies can also apply these technologies. Therefore, the main object of commerce facilitation is to contribute, speed up, and reduce the costs of transborder trade, at the same time guaranteeing security and protection regarding procedures, information exchange, documentation related among the different partners in the supply chain. In this way, for the CEPE, which is the United Nations Economic Commission, and electronic transactions of CEPAC, this standardization and harmonization of procedures and information flow necessary to move goods from seller to buyer and guarantee payment have a priority role in their economic agenda. And this is important because public entities are benefited in terms of more tax collection, better harnessing in resources, and more compliance to laws. And the benefit here, according to CITs, is a faster communication, more reliable communication, Seemingly there are some signal technical issues. Let's see whether this can be resolved. We're trying to contact him. There he is. There he is. Yes, I can hear you. We can hear you. And now we can see your presentation. Okay, perfect. I lost the signal. So then, my apologies. I was kicked out due to signal cut. So which are the benefits of technology used by CITs? And as I was saying, more reliable transactions and more uniform procedures for imports. It is not in the hands of the customs administrator according to their own criteria. Otherwise, now we have an universal criterion, more information exchange, availability of electronic information that could be reutilized by the different government areas and particulars, and also availability of the service 24 hours a day. And how do we represent this? If we take the case of Thailand, in CIT technologies with this SOL counter. This is interinstitutional collaboration in a very successful manner, representing a national emblematic project for them. Their idea was to improve facilitation of trade in their country, becoming the logistic center for the Indian China region. Since 2019, they are exchanging trade documents, zero paper, as well as transfers between government and companies, and seemingly custom dispatch faster than 24 hours. That's a lot, almost 2 hours for releasing and clearing merchandise, and automation of 660 custom checkpoints all over the country. All these reflected through this SOL counter. It represents simplification of documentation processes associated to international commerce transactions, and how this is represented in figures. This is represented practically in this manner. Logistics around this SOL counter represents savings of more than 1,500 million US dollars a year. Impressive amount.
By the use of ICT and its proper implementation and application. Well, with this, I end my presentation, but before I end, I have only one question based on what I said. No, no, the administrative application of e-justice should be performed. I think that given the results expressed in numbers and the response is given by itself, the ICT application of that technology has to be part of the political agenda of the government. It represents the growth, more tax collection, more acceleration in administrative and judicial procedures, and the state should work in the proper implementation. It facilitates the greater number of hearings, and this means more attention. The numbers, I insist, are reflected in the success cases globally. Thank you very much.